My name is Steve Parr, and I'm a Vancouver business and estate planning lawyer. And today I want to talk with you about the three documents that are the most important for setting up an estate plan. In BC, you're generally going to need a will, a power of attorney, and a representation agreement. So a will is a document that sets out what your intentions are with respect to your estate. So your estate refers to any assets, anything that you own after you pass. After you pass, your executor is going to take care of distributing anything that belongs to you to your chosen beneficiaries. There are a lot of reasons why it's really essential that you get one. The first one is that if you don't have a will, then you don't have any kind of control over who gets what after you pass. Instead, your assets are going to be distributed according to what's called intestacy law. So intestacy law in British Columbia is set out under the Wills, Estates and Succession Act, and basically it provides that the government has provided a scheme that sets out who gets what. So in general, your spouse and your children are going to receive the majority of your assets under the rules of intestacy. But if you don't have a spouse or if you don't have children, then it's going to go to your closest relative. The point being is that you don't have any kind of control over how those distributions occur. It's also going to take a longer amount of time for your assets to be distributed. So even if your estate is not substantial, even if you just have, say, a car and a small amount of assets, a small amount of investments, those are going to be locked up and waiting for a grant of administration to be issued by the BC Probate Registry. The second reason that you want to get a will if you have a family and you have children is that your will is the document that contains your appointments for guardianship. If you and your spouse, in the very unlikely event that you and your spouse predecease your children before they become adults, your will can set out who would step in as a guardian. If you don't have these guardian appointments set up inside of your will, then the process for appointing guardians becomes much, much more complicated. So in that case, you would need to involve the public guardian and trustee, and a court application would need to be made to obtain guardianship over your children. So that could be potentially a messy and complicated process that can easily be avoided through use of guardian appointments inside of your will. The third reason to have a will is that you control who controls your estate. The person who controls your estate is known as an executor. An executor is the person who distributes your assets. You may also find if you have reviewed your will or have already gone through the process of preparing a will, that an executor is sometimes referred to as a trustee as well. In some cases, the words are interchangeable and others not. Just make sure that you consult with your lawyer about the distinction between the two. But in any case, an executor is the person who will control that. And you can appoint a specific person, and you can also appoint an alternate person or an alternate. In general, most couples will appoint each other, their respective spouse, as their executor, with their first or eldest child appointed as a backup executor. However, that's not always the case and doesn't need to be. You can also choose another person, perhaps a trusted friend, or even you can appoint a corporate executor. And this can be a very good idea if you have a potentially contentious estate. So if there are unresolved issues inside of your family dynamic and a possibility that there might be some kind of dispute or tension over who gets what out of your estate, then it can be a wise move to appoint a corporate executor and just have them deal with it all. Dealing with an estate and acting in the role of an executor can be a very complicated and emotionally and energetically draining process. And so having a corporate executor can be helpful in that respect. Another reason to have a will is that you can set out specific gifts. So under the rules of intestacy, if you don't have a will, then you literally have no control over who gets what. And you may have specific prized possessions, perhaps a particular car, a piece of art, or a piece of jewelry or something of sentimental value such as a guitar that you want to give to a specific person. And if you don't have those wishes set out inside of a will, then your wishes are not legally binding. So it's important to set that out so you can make what are known as specific bequests. A will also allow you to make donations to charities. Very importantly, if you do not have a will, then an administrator will need to be appointed by the court to administer your estate. And this is a complicated and expensive process, certainly much more complex and complicated than it is to actually prepare a will in the first place. And furthermore, it can introduce complexity and uncertainty for your loved ones, as they will have to navigate the court process, how to pay for those fees in advance of obtaining control of the estate bank accounts. And there may also be confusion over who will be appointed the administrator of your estate. So particularly in a situation where there is any kind of disputes or contentions between your children or other loved ones, then this can also really complicate the process. The second estate planning document that you want to have is called a power of attorney. So a power of attorney is a document that deals with a circumstance wherein you become physically or mentally incapable of making decisions on your own. This could occur in such an instance if you become sick or unwell, enter into a coma, suffers some kind of injury. A power of attorney will grant that person, you can also name a backup attorney and a backup attorney if you wish, with authority to access your financial affairs and to make decisions of a legal nature on your behalf. You can limit the amount of authority that you grant to this person, so you can also limit it to endure for a certain period of time. There are a variety of different types of power of attorneys. So there is a general power of attorney, and there is what's called an enduring power of attorney. An enduring power of attorney will generally, the endurance aspect of it refers to the fact that that power of attorney takes effect and endures past the point of incapacity. Generally, that's how it's going to be set up for most persons most of the time. They're not going to sign off, you're not going to want to sign off on a document that immediately grants that power of attorney to your spouse or to your eldest child. You want it to only take effect after the point in time in which you become mentally incapable. And you want it to only endure for that period of time. So other things to know about a power of attorney, you can revoke it at any time. However, you cannot revoke it if you are not mentally capable, because you need to have the mental cognition to actually be able to do it. So a power of attorney is an essential estate planning document, and it's something that can literally save your family an enormous amount of time, money, and effort. It's a very simple thing to have to put in place, and it's something that should be done as soon as possible, because frankly, none of us ever know when something might occur in our lives where we need that. Another thing to know about a power of attorney is that you need to have it signed by a lawyer, or rather witnessed by a lawyer or a notary public. Otherwise, your power of attorney will not be valid to take effect inside of the Land Title Office in British Columbia. The third document that you want to make sure forms a part of your estate plan is the representation agreement. It appoints 1, 2, or 3 other persons to act as your representative. Your representative is able to make healthcare decisions on your behalf, such as what kind of medical treatments you should receive, what you are not willing to receive, and where you would reside. So things such as what kind of care facility you want to be in. So it's very important to have a representation agreement set up. It only takes effect after you become mentally or physically incapable of making those decisions on your own. This will enable your family members to take care of you in the manner in which you would have liked. And similar to a power of attorney, you can revoke or alter a representation agreement at any point. But as with a power of attorney, you cannot create a power of attorney or a representation agreement after the point in time in which you become infirm or mentally incapable of taking action of making choices of your own accord, because you must have the cognitive ability to actually appoint other persons to take care of you.